Good morning, everybody. Thank you for joining us this morning for our discussion on the implications of the Protection of Personal Information Act on your organization. I am Lucinde, Rhoodie, and I'm a director in the Dispute Resolution Department of CDH in its Cape Town office, and will moderate this session. We really trust that you find this morning's discussion interesting and very engaging. Our webinar is based on the law as it stands as at today's date, and just to note that nothing that we say on this morning's webinar constitutes legal advice. We have 4 speakers this morning, and before I introduce each of them, as well as the topics that they will be discussing, I invite you to make use of our Q&A portal. If you look at the toolbar at the bottom of your screen, you will see a conversation box with a question mark. If you click on that, it will open the portal on the right-hand side of your screen, and you are very welcome to leave your questions there during the discussion. We will have the Q&A session at the end of the presentation. Today's speakers are Kendall Keanly. She's a director in our corporate and commercial department, who will be discussing Popi in general, as well as the various conditions, direct marketing, special personal information and information officers. She will be followed by Fatima Ameer-Mia, a director in our technology, media and telecommunications department, who will be discussing security measures and steps towards compliance, as well as data breaches. Gillian, Lumb, a director in our employment department, will be discussing Popi and the employment life cycle and the areas in which Popi arises in the cycle. And then finally, I will just discuss the general enforcement provisions and powers and functions of the regulator in this regard. So we really hope that you enjoy this morning's discussion, and I will now hand over to Kendall. Thank you, Kendall.
Morning, everyone. Thank you, Lucinda. Popi applies to the processing of personal information which has been entered into a record by a responsible party who is either resident in South Africa or is resident outside of South Africa, but makes use of automated or non-automated means in South Africa. Popi applies to the exclusion of all other legislation which regulates the processing of personal information and is materially inconsistent with the object of Popi or any condition thereof. However, where another piece of legislation provides conditions which are more extensive than those provided in Popi, the more extensive conditions will apply. The terms personal information and processing have been widely defined. Personal information is defined as information regarding an identifiable, living, natural person, as well as a juristic person. It includes information pertaining to race, gender, marital status, identifying numbers such as the identity number of a natural person or the registration number of a juristic person. It also includes email addresses, physical addresses, and even the views, opinions, and preferences of a person. Processing is defined as any operation or activity or any set of operations, whether or not by automatic means, concerning personal information. It includes collection, storage of information, as well as the transfer or distribution thereof. Popi does not apply to the processing of personal information, which is for purely household or personal activities, where the personal information has been de-identified, which means that it no longer sets out characteristics which identify it to a person, where personal information is processed by a public body for national security reasons or for the prevention, identification of unlawful activities. It also doesn't apply for the processing of personal information by Cabinet and its committees or the Executive Council of Provinces. It also doesn't apply where personal information is processed for the judicial functions of court. Popi also does not apply where personal information is processed for purely journalistic, literary, or artistic expression to the extent that it is in the public interest. Popi sets out 9 conditions which must be met in order for the processing of personal information to be considered lawful. Due to the time available, I will not be discussing each and every condition, but wish to highlight a few. Firstly, Popi requires that personal information may only be processed if, amongst other things, the data subject, this means the person to whom the personal information relates, consents to such processing. This consent must be voluntary, specific, and informed, which means that a general consent to the processing of personal information will not be sufficient, and that any consent will have to be specific to the actual processing which is going to be taking place. Secondly, personal information must be collected for a specific, explicitly defined and lawful purpose, which relates to the functions and activities of the responsible party, and the data subject is made aware of that purpose. Careful consideration should be given as to the documentation in terms of which and the instances where personal information is requested or collected from data subjects. Where information is requested and isn't required or used by the responsible party in its normal functionings or activities, the request for such personal information should be removed from any documentation. Thirdly, personal information must not be retained for longer than is necessary for achieving the purpose for which the information was originally collected or subsequently processed. It may be kept for a longer period where required or authorized by law, where the data subject consents to such longer period, or where it is required for the responsible party's functions or activities. It is therefore important to assess what information is currently being stored or retained by you and whether you still require that information for your normal functions and activities. Lastly, when collecting personal information from a data subject, a responsible party must make sure that the data subject is aware of certain information. This information includes the name and address of the responsible party, the purpose for which the information is being sought, and what the consequences are should you fail to provide the information. It is therefore not sufficient to merely request that the personal information be provided by a data subject, but that this request will need to be accompanied by some form of notice providing the information required by Popi. Popi prohibits the processing of certain types of information termed special personal information. Special personal information is information which relates to the religious or philosophical beliefs of a person, their race or ethnic origin, their trade union membership, criminal behavior, or biometric information, which means fingerprints, voice recordings, and even blood type. Special personal information may only be processed where the consent of the data subject has been obtained or where processing is necessary for the establishment, exercise, or defense of a right or obligation in law. In addition to the prohibition against the processing of special personal information, Popi also prohibits the processing of personal information relating to children. As such, the personal information of children may only be processed where the consent of a competent person has been obtained. This is typically the parent or guardian of the child, or the processing of such personal information is required for the establishment, exercise, and defense of a right or obligation in law, or the information has been made publicly available by the child with the consent of the competent person. Under the Consumer Protection Act, we had an opt-out scenario when it came to direct marketing communications. Popi provides for an opt-in scenario, meaning that processing of personal information for direct marketing purposes is prohibited unless the consent of the data subject has been obtained. Popi does provide an exception to this prohibition in that you may send direct marketing communications to your customers, provided that you have obtained their contact details in respect of a sale of a product or service, and the direct marketing communication relates to a similar product or service. It is not clear how strict the information regulator will be in respect of determining the extent to which a product or service is similar to another. As such, we suggest that you obtain the consent to direct marketing communications upfront. Any direct marketing communication should still set out an option for a person to unsubscribe from receiving same. Popi increases the duties and responsibilities of the Information Officer, who was established under the Promotion of Access to Information Act, or PIA. The Information Officer is now required to ensure that a compliance framework is developed, implemented, maintained, and monitored, that a personal information impact assessment is done, and that internal awareness sessions are conducted regarding the provisions of Popi, the regulations, any codes of conduct, and any communications which have been provided by the information regulator. An information officer is the CEO, managing director, or equivalent officer of a private body, or the director general, head of department, municipal manager, or CEO of a public body. An information officer must only take up its duties as such once it has been registered with the information regulator. An information officer, however, is entitled to appoint as many deputy information officers as may be necessary to perform its duties and responsibilities under Popi. Although Popi provides for the appointment of these deputy information officers, careful consideration must be given as to who will take up these positions. Draft guidelines which have recently been published by the information regulator makes it clear that despite the appointment of deputy information officers, it is the information officer, him or herself, who will be held criminally liable for certain offences. Lastly, Popi provides for a grace period of 1 year in which responsible parties may ensure their compliance with the conditions thereof. Although 1 year seems like a long period, it is our experience that it is best to start as soon as possible in order to prevent a situation where time runs out. Thank you very much. I will now hand over to my colleague, Fatima.
Thank you, Kendall. Before we go on, I would just like you to pause and start thinking about where you would find personal information in your organization. Start by thinking of which of your business units will be processing personal information. For example, your HR department would be processing employee data or data of potential candidates in a recruitment process. Your IT department would be processing a whole range of data relating when you're hosting information, sending information, and storing information. And also your marketing department would be processing your customers' data. It's important to think about whose data you as a business hold and process. Also think about who you share this personal data with and in what form. How do you store and secure it? Do you have security standards in place? Do you collect and store personal information online? What about social media? Also, how do you dispose of personal information electronically that's no longer needed? Do you host data in the cloud? All of these considerations are really important, and today I'm going to be discussing the Popi requirements with regards to security safeguards, as well as data breaches and how to go about Popi compliance. Now, Section 19(1) of Popi states that responsible parties who process personal information must take appropriate and reasonable technical and organizational measures to secure the integrity and confidentiality of personal information in their possession or control. So let's unpack this. What security safeguards would be regarded as appropriate? Organizations should ensure that the steps that they take are appropriate within the context, and thus the level of security must be proportionately suitable in relation to the personal information being processed. For example, in a hospital which processes special personal information such as a patient's medical records, it would be appropriate to have stricter and more robust measures in place than a small business, for example, who only processes its customers' email addresses or contact information. Popi also adds in the qualifier that these steps must be reasonable, and therefore organizations should ensure that the measures, the security safeguard measures which they take are reasonable for an organization in their position or industry, and not simply against a general standard or organization which is not comparable. Again, if an organization is a bank or a financial institution which processes highly confidential financial data, one would reasonably expect the use of secure technologies such as encryption and compliance with international best practice, but the same standards cannot be said to apply to a small business which merely collects customer data for example, loyalty points. So what are the practical steps that a business can take to comply? Section 19.2 of Popi says that a responsible party must firstly identify all reasonably foreseeable internal and external risks to personal information in its possession or control. Secondly, it must establish and maintain appropriate safeguards against the risks identified. And thirdly, it needs to regularly verify the safeguards are effectively implemented and updated in response to new risks. Section 19.3 further states that organizations must have due regard to generally accepted industry security practices, which may apply to it generally or which may be required in terms of professional rules or regulations. So certain industries may have additional responsibilities. For example, those who are engaged in direct marketing or processing the personal information of minors need to ensure that they're well informed about any particular additional obligations which they have. So why is ensuring that appropriate safeguards are implemented in your organization so important? Well, I think, to be frank, now that Popi is in force, if your organization suffers a data breach, there's literally nowhere to hide. Over the past couple of years, there have been a number of reported high-profile data breaches, which you may have read about in the media. And while there may have been significant reputational damage, because Popi was not enforced, there was no enforcement action or any fines or damages claims. In reality, there are significantly more data breaches, but there was no obligation to report it, and so companies could really just do some internal damage control and kind of breathe a sigh of relief. However, to put it into context, South Africa has one of the highest levels of cyber attacks and data breaches in the world. During the lockdown period, especially as the majority of companies adopted a work from home policy, the number of reported cyber attacks rose to a staggering 300,000 cases in 1 week. So what does Popi require if your organization suffers a data breach? A data breach itself is not defined in Popi, but it generally refers to the unlawful access or acquisition of personal information by an unauthorized person. So where a data breach occurs, the responsible party has an obligation to report the breach, firstly, to the information regulator, and secondly, to the affected data subject. The notification itself needs to be made in writing as soon as possible after the discovery of the data breach, and it needs to contain sufficient information to allow the data subject to take protective measures against the potential consequences of the breach. Apart from the data breach obligations in Popi, there may also be other additional contractual obligations regarding what an organization needs to do in the event of a data breach. This may be found in your supplier contracts or even in your privacy policies. So non-compliance with the obligation to notify is actually a breach of Popi, and this may lead to the imposition of fines and penalties, which include criminal sanctions such as imprisonment. Damages can also be awarded against the responsible party, even where the breach was not notified. So in order to ensure that an organization complies with these requirements, we typically recommend that organizations should put in place a comprehensive incident response plan. So what is an incident response plan? Essentially, it sets out what needs to be done by an organization in the event of a data breach. So it would include who is assigned to respond to the data breach, what the internal response time should be, how the organization should communicate to the information regulator and data subjects, as well as other reporting requirements such as notifying internal stakeholders, for example. What we're hoping you get from this is that compliance with Popi is not just a tick box exercise or something which is a nice to have. Besides the threat of criminal sanctions and fines, Popi compliance is important because it goes to the heart of whether your customers, employees and suppliers can trust you. Although there's a period of 12 months to comply, based on past experience, your Popi compliance project is likely to take a considerable amount of time and effort. We can assist you from conception to final conclusion of your Popi compliance project and have considerable experience in conducting a wide range of projects of this nature across various industries for small businesses as well as large multinational corporations. So as a starting point, what do you need to do? Firstly, you need to understand the way in which personal information is currently collected, the way it's held, and the way it's shared in your business. This will involve a data flow mapping exercise. We then recommend that you conduct a gap analysis in order to identify where the risk areas are in your business. We can assist and work with you to prepare a practical implementation plan to assist you in implementing necessary improvements or changes in the business to remediate your risk areas and areas of non-compliance. For example, this may require changing your existing privacy policies, adopting compliance checklists, or even implementing changes to your governance structures. This also will include staff training and support. I'm going to wrap up there and hand over to my colleague Gillian Lumb. Over to you, Gillian. Thank you.
Thank you, Fatima. Good morning, ladies and gentlemen. As Lucinde said, I'm going to be addressing Popi and the employment life cycle. And one shouldn't underestimate how much information an employer is processing on a regular basis, in fact, on a daily basis. When one looks at Popi, one is considering the responsible party is the employer. It has significant obligations placed in it as a result of Popi, and the data subject is the employee. It's not only existing employees who fall under the definition of data subject, but also former employees where you may still retain information about them, and applicants for employment, successful and unsuccessful applicants, because you will be processing information in relation to both of those categories. So bearing that in mind, I just wanted to briefly look at the employment life cycle and some of the instances where processing of personal information arises and some of the conditions that come into play when you're processing that information. So firstly, if we look at recruitment, and what one needs to consider here is condition 1 relating to accountability. And that is borne by the responsible party to ensure that there's compliance with Popi and the conditions set out in Popi. So you need, for example, if you're going to use a recruitment agency, to determine who's the responsible party when you're using a recruitment agency. It may be that both you as the employer and the recruitment agency both form the responsible party in that instance, because the responsible party extends to a party individually and in conjunction with another party who may determine the purpose of and the means for processing personal information. So when you use a recruitment agency, you want to ensure that they comply with the provisions of Popi and that they have in place the relevant safeguards when it comes to processing that personal information that they're assembling from applicants for employment. Then moving on to the advert that you place. There are many employers who place adverts where they don't necessarily identify who the potential employer is, and they may not set out the employer's address in that advert. You may, in compliance with Popi, now need to relook at that, where condition 5 establishes information quality, and there's an obligation on the responsible party to notify applicants for employment of the responsible party, who that responsible party is, and notify them of the address of the responsible party. Then when it comes to selection, very often employers are looking at activities of applicants for employment on LinkedIn and Facebook. The conditions typically require, or generally require, that you assemble personal information from the applicant or the employee, him or herself, but there are exceptions to that. And so, for example, if you go onto Facebook and look at an applicant for employment activities on Facebook, that is acceptable because the applicant themselves have put that in the public domain. They've made that part of public record, and you are then allowed to collect that information from a source other than the applicant, him or herself. You also need to consider the condition relating to destruction of personal information and not retaining it for longer than is necessary. And when you look at applicants for employment, even unsuccessful applicants, you potentially want to secure consent from them to keep the information that you've assembled from them for a certain period of time. Particularly if you notify them that they've been unsuccessful, they may at a later date want to refer a dispute in relation to their not being successful, and you'll then retain that information for a certain period of time. So upfront, wanting to secure their consent to obtaining their personal information for a period of time after they've been notified that their application was unsuccessful. Then looking at the interview process and condition 2, which relates to minimality. And I think here you need to look at, when you are interviewing someone, what sort of questions are you putting to them? Are there questions that are necessary, relevant and minimal, and that you're not going into assembling personal information which is in breach of condition 2 relating to minimality. Then once you get into offering someone employment and the contract of employment, that is typically where you're going to want to look at securing their consent to the processing of their personal information. Remembering here, consent is a voluntary, specific and informed expression of will, and that the obligation and the onus is on the employer to establish that someone has given consent to the processing of their personal information. And we'll need to see how the information regulator interprets consent. But I thought it was important to look briefly at a decision in 2019 of the Greek Data Protection Authority, where they fined an employer a not insignificant amount of 150,000 euros, where the employer had secured consent from its employees to the processing of their information. And what the authority determined was that the employer shouldn't have secured the consent from the employees. That should really be the last legal basis on which you secure the entitlement to process information. And what the employer should rather have done was rely upon either the performance of the contract of employment, a legal requirement placed on the employer to process personal information, alternatively, that there's a legitimate interest of the employer that the employer was pursuing. And that, as I said earlier, the last resort should be securing consent from the employees. And the reason for the authorities finding in this regard was that typically there's a power dynamic between an employer and an employee. And it's very difficult to be able to establish as an employer that you have secured someone's consent and that it's been genuinely and freely given. So one needs to bear in mind decisions like that, which we've had coming out of the EU in particular, where they've had significant legislation in this regard for a much lengthier period of time than we have obviously had in South Africa. Then if we look at the induction process, very often employers will look at securing employees or applicants for employment's biometrics to gain access to the workplace. And I just wanted to look then very briefly at condition 4 relating to further processing limitations. And one needs to bear in mind as the employer that if you have, for example, secured someone's fingerprints for access to the workplace, you can't necessarily then go and use that same information at a later date, for example, to check whether someone has a criminal record. And you've got to ensure that the reason you then further processing it is compatible with the reason that you initially secured that information. Then looking at the next phase, the day-to-day operations, when someone's in your employment, if you're going to, for example, use an external agency, a payroll administrator, to assist you with your payroll, you want to ensure in accordance with condition 7 that they have the necessary security in place, and that if there's any security breach, that they notify you immediately. Then during the course of employment, you will, on occasion, have the need to discipline employees. And here we need to consider doing your investigation where Popi may come into play. If you're going to, for example, investigate allegations of CV fraud, you may be looking at other sources where you're going to get information from. And ideally, you'd want to try and secure consent right up front when someone enters your employment to the fact that you're going to potentially then be processing information during the course of an investigation, and that they give you that consent to do that. And then finally, when someone's leaving your employment and you're going to issue them with references, you need to consider whether you've secured upfront from them their consent to give references, bearing in mind that processing of personal information is very broad, and that personal information includes where you're expressing a view or opinion on someone who may have left your employment. So from an employment perspective, and in summary, one needs to consider the full gamut when someone is coming into your employment potentially, right to when they're leaving your employment, and looking at what information are you gathering, what is the quality of that information, who are you securing that information from, do you have the necessary security measures in place to safeguard that information, have you trained your employees, bearing in mind that in terms of section 99, you now have a statutory vicarious liability as the employer party, where employees of yours breach the legislation, you may be held liable for that and subject to fines. And then finally, that you ensure that you've got policies in place which include provision for employees to have access to the personal information that you have about them and to rectify or correct that if there are errors in relation to that information. Thank you very much. And if I can then hand over to Lucinde. Thank you.
Thanks Thank you, Gillian. I would like to take you through the enforcement provisions as set out in Popi, dealing specifically with the wide investigative and enforcement functions and powers of the information regulator. Now, the regulator has the power to receive and investigate complaints, to gather information, and also to attempt to resolve complaints through mediation and conciliation, and also to make assessments in terms of Section 89 of the Act. Before I deal with the issues of complaints, I would like to briefly touch on the issue of assessments. In terms of Section 89, the regulator must, on its own initiative or at the request of a responsible party, data subject, or any other person, make an assessment of whether an instance of processing of personal information complies with the provisions of the Act. In such an instance, the regulator may serve the responsible party with an information notice, requiring the responsible party to furnish the regulator with a report indicating that the processing is taking place in compliance with the provisions of the Act. The regulator must inform the parties of the result of the assessment, but the Act is not clear what the consequences of such a report is. This might be dealt with in the regulations, or we may, through court proceedings in due course, see how the status of these assessments are being dealt with. The Act in Section 74 makes provisions for two types of complaints to be submitted to the regulator. The first complaint is a complaint by any person that allege an interference with the protection of the personal information of a data subject, which includes any breach of the conditions of the lawful possession of personal information or a breach of the provisions of any code of conduct issued by the regulator. Or a responsible person or a data subject may submit a complaint to the regulator if it is aggrieved by the determination of an adjudicator in terms of the code of conduct. So what can the regulator do when it receives a complaint? It can conduct a pre-investigation in terms of the Act. It can act as a conciliator. It can actually decide to take no action, or it can go over to conduct a full investigation, or finally it can refer the complaint to the Enforcement Committee, which is being established in terms of the Act. And interestingly enough, the Act requires that one of the members of the Enforcement Committee must either be a judge, a regional magistrate, an advocate, or an attorney. As soon as the regulator receives a complaint, it must inform both the complainant as well as the responsible party of the details about the complaint, the right of the responsible party to submit to the regulator a written response in relation to the complaint, as well as the proposed course of action it intends to adopt. The Act provides the regulator with very wide investigative powers. It has the power to summon a person to appear before it, to give evidence, and also to produce documents. The regulator may, with a warrant, enter and search any premises occupied by a responsible party and conduct private interviews with the persons in such premises. The provisions of the Act that deals with the issuing of warrants is quite novel, and it's not the same as found in any other similar Act. It provides that a judge or a magistrate may only issue a warrant for the regulator to enter upon a premises if the regulator has given the occupier of the premises 7 days notice demanding access to such premises, and either such access has been refused or access has been granted, but the occupier just refuses to comply with any reasonable request of the regulator while it's on the premises. And then again, only after such refusal, the occupier has been notified by the regulator of the application for a warrant that is being made and has had the opportunity of being heard on the question whether the warrant should be issued. These requirements, of course, does not find application in the event of urgency or if the regulator can convince a judge or a magistrate that compliance would defeat the object of the entry. If one looks at what the purpose of a search warrant is, it's unlikely that the regulator will ever approach a judge without alleging grounds of urgency or that compliance would defeat the object of the entry. Any person or entity or responsible person whose premises are being entered must be advised of its entitlement to legal representation and must in fact be allowed to exercise such rights. And also importantly, no self-incriminating answer is admissible as evidence in later proceedings unless such later proceedings relates to the criminal charge of perjury. So after the investigation has been completed, the regulator may decide to take no action, and the Act sets out the factors that the regulator can take into account in deciding not to take any action. For example, that the complaint is frivolous or vexatious, or that the time period between the alleged breach and the making of the complaint is just too far removed from one another, or the regulator can decide to refer the complaint to the Enforcement Committee to consider, make a finding as well as a recommendation in respect of the proposed action to be taken by the regulator. After receipt of the Enforcement Committee's recommendations, the regulator must issue the responsible party with an enforcement notice, setting out specific steps to be taken, or order the responsible party to stop processing personal information. The information notice must advise the responsible party of its rights to appeal, and the Act differentiates between the process to be followed by responsible parties who wants to appeal and complainants. If a responsible party on who an enforcement notice or an information notice in the context of assessments have been served, has a period of 30 days in which to appeal to the High Court to set aside such notice. A complainant who has been informed of the result of the investigation being either that no action is going to be taken or the enforcement notice has been cancelled, which the regulator is entitled to do, may within 180 days of receiving the result appeal to the High Court having jurisdiction. Fatima touched on this briefly, but the Act also makes provision for either a data subject or the request of the data subject for the regulator to institute civil action for damages against the responsible party for breach of any provisions of the Act. It is unclear whether this provision takes away a data subject's common law rights to apply for interdictory relief against a responsible party. In my view, it can never infringe on the common law rights of a data subject in this regard. The Act then also goes ahead and sets out certain of the defences that the responsible party may raise in the event that such an action is being instituted, and these include consent of the plaintiff, fault on the part of the plaintiff, that compliance with the Act was not reasonably practical in the circumstances, or that the regulator has granted an exemption in terms of Section 37 of the Act. Again, I can't see that the Act can limit any other possible defences which a responsible party may raise in the event of such a damages action to be instituted, but we will have to see how the court deals with this issue in due course. The Act sets out various offences in terms of non-compliance with the Act, and the most important is offences relating to obstructing the powers and functions of the regulator, obstructing the execution of a warrant, as well as failure to comply with enforcement or information notices. The penalties in the offences differ from offence to offence, but generally it varies from a fine to imprisonment not exceeding 1 year up to imprisonment not exceeding 10 years, and that is specifically in regards to obstructing the powers and functions of the regulator or failure to comply with enforcement or information notices. Interestingly enough, the Act has an entire section dealing with administrative penalties which the regulator can impose up to an amount of 10 million rand. If the regulator, after receiving a recommendation from the Enforcement Committee, decides to impose an administrative penalty, it must deliver an infringement notice on the responsible party. The infringement notice must specify the particulars of the alleged offence, the amount of the administrative fine payable, and also inform the infringer that no later than 30 days after the date of service of the infringement notice, the infringer may either pay the fine or make provisions to pay the fine, or, interestingly enough, elect to be tried in court on a charge of having committed the alleged offence referred to in the Act. The two options are completely or are mutually exclusive. So the regulator may not impose an administrative fine contemplated in this section if the responsible party concerned has been charged with an offence in terms of this Act, and no prosecution may be instituted against a responsible party if the responsible party concerned has paid an administrative fine in terms of this section in respect of the fact, in terms of the Act. So that brings us to the end of the presentations by the four speakers. Thank you very much for joining us. We will now move over to the question and answers portion of the webinar. We received quite a lot of questions. So what I'm going to do is I'm going to start with the questions and then just refer it to the specific speaker that's going to assist. So firstly, we received a question from Anonymous asking, can I send an unsolicited email marketing campaign without falling foul of any law? I'm going to request Kendall to deal with that question.
Thank you, Lucinde. The Popi makes it clear that direct communications or direct marketing communications can only be sent where the consent of the data subject has been obtained, or you've obtained the details of the person because they're a customer of yours. So I think the question here is, if you obtained a consent from the data subject, or they're a customer of yours and you're sending them direct communications, then it should be fine. If you haven't obtained their consent, or they're not a customer of yours, then no, you cannot send direct marketing communications to them.
Lucinde, please unmute.
Sorry about that. Thank you, Kendall. Another question for you. Are employers already constrained in processing the personal information of its employees and disclosing same to third parties from promulgation on 1 July 2020, or will that only kick in 1 July 2021?
So the Act does provide, obviously, for this 1 year grace period in order to ensure that you comply with the provisions of Popi. It's not clear, and no indication has been given in Popi as to what happens if you do fall foul of the provisions of Popi during this 1 year grace period. I think it's safe to assume that if there's sort of a major sort of non-compliance and the information regulator starts having investigations and they see that you haven't taken steps to even start compliance, that I think you're going to be in a bit of trouble. But we always suggest start now. It does take a long period to ensure compliance, and a year is definitely not enough. Thank you.
Okay, thank you. Kendall, just one final question for you, and I think it's actually a very interesting question. It is the rules of Popi applicable to deceased persons? I work in the insurance industry and conduct forensic investigations regarding death claims. Is the information of a deceased person protected under this Act?
That is actually a very interesting question. And if you look at the definition of personal information in Popi, it says that it's information that relates to an identifiable living natural person. So it won't actually apply to the deceased person. But if you're going to do forensic investigations and you're investigating sort of the beneficiaries, whether they should have been entitled to actually claim the death benefits under the insurance policy, then that information concerning the beneficiaries, because they are still alive at the time, that probably will apply to that information.
Okay, thanks, Gillian. We've got another question from Andre, which I'm going to ask Fatima to deal with. Andre asks, would Popi prohibit a company from disclosing the names of its shareholders and their shareholding as contained in its share register? Section 26 of the Companies Act requires a company to disclose its share register to any third party on request. Would Popi override these provisions in the Companies Act?
Hi, thank you. That's an interesting question. I think that Popi is not going to override those provisions in the Companies Act. It's still permissible to share that information because it's something which is required by law, and that's one of the exceptions under Popi. So what would not be permissible is that if you use that shareholders' information for a different purpose than which it was collected. So, for example, if you start taking the shareholders' information and you start using it for direct marketing purposes, for example, then that's something that wouldn't be allowed for under Popi unless you've gotten the express consent from those shareholders to do that.
Thanks, Fatima. We've got a question from Rob, which I'm also going to ask Fatima to deal with. Rob asks, if a telecommunications company, or in a telecommunications company, then I presume and act like RICA would determine the retention requirements of personal information.
Sure, thanks, Rob. So yes, you're correct. What Popi says is that you cannot retain information or personal information for longer than is necessary for you to achieve the purpose for which the information was originally collected. So if the information was collected for RICA purposes, then you can retain it for the retention periods stipulated therein. And that applies to also any personal information which is required to be retained for in terms of other applicable legislation. So, for example, your employment legislation, your tax legislation, or your company legislation may require certain information to be kept for certain periods. You can keep the information because you're required to keep it by law, but if you collected that information for a different purpose, you can't just keep information forever. That's essentially what Popi's saying you trying to regulate against.
Thank you, Fatima. The next couple of questions relate to Gillian's presentation on the employment section. Gillian, the first question is, can comorbidities health, can we ask for this information? Who can have access to it? COVID employees, can this be divulged as need to check for exposure?
Thank you, Lucinde. What we need to appreciate here is that there's obviously overriding legislation in terms of dealing with the disaster management legislation and the regulations, and that employees and employers have obligations in respect of COVID-19. The employer has the obligation to make disclosures where someone is COVID positive to both the Department of Employment and Labour and to the Department of Health. So those obligations an employer will need to comply with, notwithstanding the limitations and restrictions in terms of Popi. Likewise, where you need to do contact tracing, you have an obligation in terms of the legislation to notify employees who may have been in contact with another employee who's COVID positive that they may need to self-quarantine or take certain steps to be tested. So for purposes of complying with that legislation, Popi and the special personal information relating to health will still be addressed, and those restrictions won't apply where you're complying with COVID-19 related regulations and legislation.
Thanks, Gillian. We've got another question from Cynthia, which we would like you to answer. Cynthia says, good morning. How sure are you as an individual that your info will be discarded after an unsuccessful interview, or you left the company you worked for? Please advise.
Thanks, Cynthia. That's a question which is dealt with in terms of the conditions where you have an entitlement as a data subject, which would include then an applicant for employment or someone who has been in someone's employment and left the employer's employment, to gain access to and question what information the employer may still hold about you. You have the right to understand what information they have about you, and if it is out of date, to update that information or correct it. And that would then also extend to ensuring that it's not kept for a longer period than is necessary, bearing in mind that the conditions require that an employer not retain that information longer than is necessary for the purpose for which you initially collected that information. So you do have the right then to check, once you've left someone's employment, what information they may still have of yours and how long they're retaining that information.
Thanks, Gillian. One final question. Fernanda asks, what about telephonic requests for confirmation of employment?
Thanks, Fernanda. That's something which would also be dealt with under Popi, because you are then giving information relating to an employee and their employment history. So it would certainly fall under processing of personal information, and that if the person who's receiving that information is also keeping a record of that and taking it into account in making a determination, that would fall under the conditions, and you'd need to ensure that there is compliance with the conditions in processing that information.
Thanks, Gillian. We've got a question about the grace period. I'm going to ask Kendall to answer that. The question is, please confirm when the 1-year grace period will start.
Thanks. The 1-year grace period starts from the date of commencement, so that would have been the 1st of July 2020, and it will run until the 30th of June 2021.
Thanks, Kendall. Just one further question for you. Jessica asks, in a group scenario, can an information officer be appointed for the entire group, or must an information officer be appointed at each entity level?
Thanks, Jessica. Popi indicates, and PIA as well, where the information officer was originally created, that it is the private body or a public body that must appoint an information officer. So it would appear that every company in the group will need to have an information officer. They obviously will have different functions. So your group, let's say information officer, sort of in your holding company, will have more extensive duties and responsibilities, whereas the information officers in the sort of subsidiaries will have those sort of duties and responsibilities that relate only to that specific subsidiary.
Thank you. Thank you, Kendall. There was one question that I want to refer to Fatima. Just quickly want to find it. Apologies. Oh, here we go. I'm going to hand this over to Fatima. The question is actually two questions. Under the GDPR, the processor, who is equivalent to the operator under Popi, is subject to sanction. Is the operator similarly sanctioned under Popi? In the case where the operator is, for example, an IT company hosting information, it has no knowledge of the information it is holding.
Thanks, Lucinde. So before I answer that question, I think there was a previous question around GDPR and also around the role players in Popi. So I just want to kind of answer the questions together. So, so under Popi, you get two role players essentially, which are involved in the processing of personal information. You get the responsible party, who is essentially any public or private body which determines the purpose and means for processing of personal information, and is usually the person who is collecting the information directly from the data subject. Then you also have what is known as the operator. Now, the operator is the person who processes personal information on behalf of the responsible party in terms of a written mandate. So you can essentially outsource the processing of your personal information to a third party. And the operator has certain obligations under Popi, most notably around securing the information, so using the security safeguards, etc. Now, the GDPR, that is the legislation or data protection legislation in Europe, which has recently come into force. It came into force about 2 years ago, and what's important to note is that Popi was modeled on the EU directive, which is what the GDPR was also modeled on. So Popi and the GDPR are very, very similar. I would say they are almost, I would say like Popi is about 95% the same as the GDPR. It follows the same approach. So if you are compliant with Popi, you would be substantially compliant with the GDPR, but there are notable exceptions. So to go to the question around the different role players. So under Popi, you have the responsible party, and that is equivalent to the controller under the GDPR. And under Popi, you've got the operator, which is equivalent to the processor under the GDPR. Now, Popi doesn't specifically make provision for the operator to be held liable for administrative fines and sanctions in the same way that the GDPR does. So that I think that answers that question. And if you, and I think one of the questions was, if you comply with the GDPR, are you compliant with Popi? Again, substantially you would be. But there are some differences which you would, there are notable differences. So for example, Popi applies to personal information of juristic persons as well, which is not the case in terms of the GDPR.
Thank you, Fatima. We have a question from Yaku, which I'm going to ask Kendall to assist with. Yaku asks, to what extent should terms and conditions of sale and purchase be amended to ensure Popi compliance?
Thank you, Yaku. You'll have to include provisions with regards to data protection in your sales terms and your purchase terms. You'll actually have to also include certain provisions whereby the data subject actually consents to the actual processing of their information, as well as providing them with some details as to what actual processing is taking place. So I would suggest that you make those sort of amendments to your terms and conditions.
Thank you, Kendall. We have time for one question before the end of the seminar. Before I hand over to Kendall, we really want to thank all of you for joining us this morning. And insofar as we haven't gotten to your questions, we will endeavour to answer them in alerts that we will publish on Popi and on the subjects dealt with today in due course. So before we end up, I'm just going to hand over to Kendall for the last question. It comes from Junior. Junior asks, for the purposes of direct marketing, does the customer's consent apply continuously, or should they consent periodically, alternatively at every instance of direct marketing?
Thank you, Junior. That's actually a very good question. Popi doesn't provide any sort of indication that says the consent is only valid for a certain period, but I think that it will be just good practice that at least once every year you just check with an individual. You know, you provide them with the communication saying, this is the information that we have on record for you. We're going to send you direct marketing communications. Do you still want to receive same? I think that's just going to be good practice going forward.
Thank you, everybody. That's it from us. We hope you enjoyed it, and we hope to see you soon for our next webinar. Have a good day. Thank you. Bye-bye.